Yes, ma'am.
Can you just go over the procedure to get a copy of the petitions of other candidates running in your race? So once they file their petitions, for example, what is the procedure that you go through to actually get a copy of those?
You can file a Freedom of Information request. We have forms for that purpose up on the 6th floor and 8th floor of the board. You fill that out. We'll try to turn around copies as quickly as we can. We've got extra machines, extra people geared up. We've ordered extra paper. So we're going to try to turn those around as quickly as we can. I can't give you a deadline, but it'll be, I hope, within 24 hours. But don't hold me to that, okay? All right, so we're going to move on. Appearances. Again, it's absolutely essential you show up at the first hearing. If you're a candidate and you've been served with a copy of the call and we have proof of service and you don't show up for that initial hearing, we're going to enter a default judgment against you, and your candidate's papers are going to be declared invalid. If you're an objector and you fail to show up at the initial hearing, and we have proof of service in the file, there's going to be an order dismissing your objector's petition, and that's going to be dismissed. And there's very little room for reconsideration. Very, very little room. Very seldom is that kind of decision overturned by the board. So it's important that you be at the first hearing. Who can appear? A candidate can appear, an objector can appear, or an attorney, a licensed attorney in the state of Illinois can appear on behalf of a candidate or a party. Non-attorneys cannot appear on behalf of either candidate or objector. It used to be back in the day they had people who, you know, had been around the block a few times and were very knowledgeable about the process, and they would come in and talk to candidates and objectors and represent them, or attempt to represent them. They are not permitted to do that any longer. It's the unlicensed practice of law, and there could be some serious consequences for doing that. So the attorney, the named party, can represent himself or herself. You do not need an attorney. It's not required. So you can represent yourself. When we get to records examinations, if you need to bring in people to help you, and you probably will, those people can be non-attorneys. You're not required to have a licensed attorney represent you during the records examination. Once we get started, the parties have to make themselves reasonably available by telephone during the day, at least until 7 p.m. for receipt of notice from the board or from opposing parties. Some candidates, this is particularly true among candidates, some candidates, once they file their nomination papers, they sort of go underground, and you don't know where they are, you can't find them. Sheriff's deputy goes out, knocks on the door, no sign of life, send the mail out, and there's no pickup, no return receipt. They sort of disappear from the face of the earth. That's not really going to guarantee you success here. Because in the end, all we have to do as an electoral board is show that we followed the process, that we gave it to the sheriff, and the sheriff went out there, and he knocked on the door, and no one answered. Or that we gave it to the Postal Service with a certified mail return receipt, and they went out there, and they delivered the mail. If we show that we complied with the requirements in the statute for service, you have been served. So don't think that by disappearing and going underground, you're going to somehow dodge an objection to your nomination papers. Okay? As I said before, time is of the essence. I can say it too often, and sometimes I do, but it's important. Time is of the essence. We have to expedite these proceedings. No continuances. That's the general rule, unless you have a really good reason. Now, what we do at the initial hearing, sometimes we have a candidate who will show up with a copy of the objections in hand, and they say, I've been trying to get an attorney. I know I need an attorney. I've been trying to get one. I haven't been able to get one. The hearing officer will give you a reasonably short period of time to go out and find yourself an attorney. But generally, again, there's no continuance. That's the rule, because we've got to move these cases along. Again, the election is not going to be pushed back. We have to be ready. At the first hearing, what's going to happen is they're going to conduct a case management conference. And the hearing officer is going to go over what the issues are in terms of what the objector is trying to bring forward. If there is an objection to the signatures, the validity of signatures, they can only be determined with a record examination by checking the board's voter registration database. They will send it to a records examination. If it involves a question of fact and a question of flaw, for example, residency is one, then they're going to talk to the parties, they're going to outline what the issues are, they're going to try to identify what witnesses need to be brought forward and what evidence needs to be subpoenaed, and how many subpoenas are necessary, where they need to be served, how long is it going to take to get them served, and they're going to set up a schedule. They're going to set a date, a hearing date, or they may set a pretrial hearing date in order to make sure that everyone is going to be ready for the hearing. And again, they will have a discussion about what the issues are, what both sides are prepared to bring forward in terms of evidence, as far as testimony from witnesses, and what they need to do to be prepared for the hearing. So the case management conference, the initial hearing, is going to be the opportunity to kind of sort things out and to create a roadmap for going forward and a timetable for going forward. There is no requirement that a candidate file an answer to the petition. If the objector has alleged that all your signatures are bad, you are not required to file an answer saying that's not true, they're all good, okay? The allegations in the objector's petitions are deemed denied until more evidence is presented, more proceedings are conducted. It is not required that you file an answer denying all the allegations in the objector's complaint. If you want to do so, you can do so. It may be possible that you can admit certain things, and it will help the process along. If there are certain things, certain weaknesses in your papers or your case, you can admit those facts, and the parties will then not be required to bring in evidence to support those particular facts. And so if you want to file an answer, you want to admit certain things, you want to deny certain things, you can do so. You're not required to do so. Another avenue here for the candidate is to file a preliminary motion, a motion to strike and dismiss the objector's petition. And again, that's not just a denial saying, no, all the facts that you allege in your objector's petition are not true, they're false. That's just a denial of fact. And we're not going to strike an objector's petition just based on that denial of fact. But there may be some issues that warrant a dismissal of the objector's petition. For example, the objector must be, if you're running, for example, as alderman in a ward, the objector has to be a registered voter in that ward. if you allege in a preliminary motion to strike and dismiss that the objector is not a registered voter in your ward, and it's proven that that objector is not a resident or a registered voter in that ward, that objector's petition will be dismissed. So really a preliminary motion, a motion to dismiss, is testing the legal sufficiency of the objector's petition or the legal standing of the objector to be an objector. So it's a test, a legal test of the objector's petition. There may be certain issues of law that he has raised that are decidedly in your favor when you examine the law. You are absolutely correct and supported by the law. You can raise that in a preliminary motion. You can say, Mr. Objector has said X, Y, Z, but the law in Illinois says that is not a sufficient basis to invalidate my nomination papers. And if you are correct on the law, the objector's petition will be dismissed, or at least will be dismissed and stricken as to that particular issue. So, you know, the objector's petition can be dismissed in its entirety, or if there are certain issues of law or fact in there that are not going to stand up, at least those aspects of the objector's petition can be stricken. So then you can move on with what else is on the table. Now, if you're going to file a preliminary motion, there are strict deadlines for doing so. You have to file with the board and serve your opponent by 5 p.m. of the next business day. So if we have initial hearings on December 6th, a candidate must file the preliminary motion by 5 p.m. on December 7th. The objector then is going to be given the following day by 5 p.m. to follow or file a reply. And then the hearing officer may set it down for a hearing and hear argument from both sides as to why the preliminary motion, the motion to strike or dismiss, should be granted. And if they do not grant the petition or the motion to dismiss the entire petition, then we're going to have to go forward with what's left in the objector's petition. So please be mindful of these deadlines in the very beginning, because if you fail to file a motion, a preliminary motion, in a timely manner, the candidate is deemed to have waived any objection to the objector's petition. So whatever valid argument may have had may be gone.
Is there anything in the process that allows people to understand, like, sort of who's behind the objector?
Okay. So the question is there any way in the process to sort of reach beyond the objector to find out who's really behind the objection? And the answer is no. Because Illinois law is pretty clear on this point, that if you meet the statutory requirement of being a registered voter in the district, you are eligible and qualified to file an objection, and it makes no difference. It makes no difference who may be behind the objection. I mean, it's probably your opponent, right? But those are political issues, and if you want to hash that out in the media, you're more than welcome to do that, but in this process, it really does not make any difference.